Basically every month, and we propose legislation and changes to the probate rules. And so I and other attorneys have gone to the legislature to lobby in favor or against some of the provisions in the law. So that's just by way of background. So again, this is going to be real basic. I was just looking at the in your materials. I'm on chapter 18, page 288, where they're going over the basic questions. And I thought we'd just kind of walk through that, and that helps me just kind of go through the legalities. And by all means, if anyone has any question about anything, please speak up, because for me it's really boring if it's just me talking, and it gives me an idea of what points I can clarify if you folks go ahead and ask questions. So the first thing is, what's a will? And let me say, I believe very strongly that everyone should have a will. Even you know, when my son went off to college, I made sure he had all the necessary estate planning documents, because you never know what will happen. For him, I was primarily concerned with powers of attorney and healthcare directives, but he has a will also. I also knew that my husband, before we got married, really loved me, because in his will, he left me his TR4, which was his pride and joy. I think everything else went to his parents, but that was okay with me. Your materials say that the will takes effect upon the death of the testator. The testator is the name of the person who signs the will. In archaic terms, sometimes it's called a testatrix if you're a woman. We're a UPC state, so testator applies to everybody. And while it's true that a will takes effect at the death of the testator, what a lot of people don't understand is that it needs to be admitted to probate before anyone has the power to act as executor or personal representative of the estate. In Hawaii, the executor is called a personal representative. That's the term that's used in the UPC. But when you're talking with clients, a lot of them think of it as executor. So I try in my meetings to let them know that it's really one and the same. But but a lot of times people just think because they're named in the will that they're automatically the PR and they can run around, you know, taking care of the administration of the estate, and that is not the case at all. They need to be appointed by the court. Now there is one exception to that. If the assets that are otherwise subject to probate are worth less than $100,000, then there's a very simple affidavit of collection procedure. And that's $100,000 excluding the values of automobiles. So you could have, you know, $90,000 in a bank account and a $100,000 automobile, and you could still use the affidavit of collection procedure. And what it is, it's basically verifying that the person is deceased. You have to submit a certified copy of the death certificate with the affidavit, and you're certifying that you're the successor, and you're identifying the properties that are to be collected, and you're certifying that all the assets are worth less than $100,000. So that comes in handy when you're dealing with small bank accounts or automobiles. And in that case, you don't need someone to be appointed to take care of it. And I've only had one case where someone came in with an affidavit of collection, and then someone else came in with an affidavit of collection. And, you know, that can cause some trauma, obviously. The person, the banker, or whoever's relying on that affidavit of collection under the statute, so long as they're presented with the death certificate and the verification that the person's a successor, they don't have any duty to inquire whether they actually are. They could rely on it, and so they're not liable. In the case I'm telling you about, the person who is not entitled to the property collected the property, and we ended up in another litigation matter to recover it. Going on to what are the requirements for a person making a will, they have to be legal age, which in Hawaii is 18, and they have to have the requisite capacity to make a will. And that generally means they have to recognize, know who the natural objects of their bounty are. And typically that means, you know, their spouse, their children, their immediate family. Sometimes if they don't have immediate family, the natural objects of their bounty might be friends or might be charities. But you kind of need to know a sense of who the person is and what the relationships are to make that determination. They also have to be able to identify their assets and know the extent of it. Now, they don't need to know, you know, dollars and cents, you know, but with real estate, they should know where it's located. They should generally know what a value is. Similarly with bank accounts. And then they have to have enough capacity to have a plan, to be able to formulate a plan, and recognize that the plan they're formulating would go into effect at their death. You know, for 99% of the people you're dealing with, it's not an issue. But there's always that 1% where they're really old and it can be a little more difficult to ascertain. If there's any question in your mind, you really need to get a doctor's opinion. You have to tell the doctor what the legal standard is. You have to give the doctor enough information about their background and history and their property so that the doctor can test them on those particular questions. And then you also have the issue that you have to be sensitive to, and that's the issue of undue influence. And when you're dealing with older clients, and particularly, well, oftentimes perhaps their children are on the mainland and maybe someone else has kind of intervened in their life and may be taking advantage of them, maybe not. But you have to be sensitive to that, and again, have a doctor evaluate, you know, whether the person is susceptible or vulnerable to such influence. In your materials, it talks about clauses that are essential to all wills, and I have to say, I don't think all those clauses are essential. I mean, typically you do want the document in the first paragraph to say, I intend this to be my last will and testament. Typically you do want it to say where the person is domiciled. Although there are often clauses identifying the spouse and the children, that's not an absolute necessity. The reason you do it, though, is because it helps establish capacity. You know, if they're able in the document to identify their spouse and their children, then you can check off that box, and it's proof that they knew the natural objects of their bounty. It's also important if they want to disinherit someone. If they're going to disinherit a spouse or a child, it's very useful to say that specifically. And usually I put it in the family provision. And again, the reason is you don't want there to be an inference that they simply forgot. And they really meant to include that person, or any question about capacity. So you want to identify the family members. If they're going to disinherit anyone, say it right up front. And sometimes there's a debate as to whether you put the reasons or not. I generally do not put the reasons because perhaps those reasons aren't correct. Who knows? So we just generally say I intentionally make no provision for, you know, this particular person. Obviously, you need a provision that talks about who's going to get what when. It should have a provision talking about the payment of the debts and the taxes and the expenses of administration. It's not automatically required. There's provisions in the probate code that will address how the expenses should be allocated if the will is silent on it. And that typically becomes an issue if you're in an estate tax situation and you want to make sure, okay, who's going to bear those taxes? Are they going to be borne by all the beneficiaries in proportion to what they're receiving? Or are they only going to be borne by the residuary beneficiaries who are going to get the bulk of the estate? The latter is usually the way it's handled, primarily because if you're making, let's say a $10,000 gift to this person and $25,000 to that person, most people don't want them to have to then pay a part of the estate tax. But sometimes you'll have clients who do want it apportioned. In terms of the witnesses to a will, under our statute, 2 witnesses are required, and then what I passed around was Section 562-504 that sets forth the express language for a self-proved will in Hawaii. So if your will contains this attestation clause, then it's automatic. You don't need to have witnesses come forward and say, oh, I witnessed that signature. So this is, every lawyer attaches this to the will because it simplifies things immensely. But sometimes when you're dealing with old wills, or perhaps wills that were done in another jurisdiction, you might have to track down the witness and get them to verify that, yes, that's their signature, and yes, they witnessed that will, and yes, that person was of majority age and had capacity and was not being unduly influenced when they signed the document. It's also possible if they were domiciled in another state when they executed the will. Sometimes you can present that state's law to the court and say it complied with the laws of that jurisdiction and get it admitted here. But you have to look at that a bit carefully. I'm on to question number 5. After the will is executed, who keeps it and how is a will revoked? In the olden days, I think, it's my understanding that law firms typically kept the original will for their clients. That is not the general practice now. And the reason for that is because there could be potential liability if you lost the will. I think it's probably too kind of a storage issue. So I think the predominant practice is for the attorney to return the original to the client, usually by certified mail, or if you're going to hand deliver it to them, have them sign a receipt. It's very, very important to establish who received the original will. And then you need to advise the client to keep it in an extremely safe place, such as a fireproof safe at home or in a bank safe deposit box. And the reason that is so important is because if we can't find the original will when someone's passed away and they were the last person to have it, it is presumed that they revoked it. And the reason there is that presumption is because you can revoke a will by tearing it up, by throwing it away, by destroying it, by burning it, what have you. So the presumption is if we can't find the original, it's revoked. Now you can overcome that presumption. So for example, if it was in a house that burned down, okay, that would rebut the presumption. Or if they gave it to, auntie or uncle to hang on for them, that would also rebut the presumption. But I have been involved in a couple of cases where we couldn't find the original will, and we had the heirs at law who were not going to take under the will, who successfully challenged the will on the basis of the presumption that it was revoked. So in that case, then, the heirs would take it instead of the people who were designated as beneficiaries under the will. Okay, any questions so far? Yes?
So what happens if there's a copy of the will, but not necessarily the original will? Because sometimes the copy is given to the attorney or somebody else or the bank, but
right.
They don't have the original. What
right.
happens in that case?
Well, yeah, the attorney usually should keep a copy of the will. As I said, it's presumed if you can't find the original that it's revoked. Now, I have had cases where the whole family has agreed, okay, even though we can't find the original, we all know this is what mom or dad wanted. And so we will agree that this can be probated. And you can probate it if everyone agrees. But if there's a challenge to it, you have to be prepared to try to rebut the presumption that the reason we couldn't find the original isn't because mom or dad revoked it, it's because it got lost or